Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinar brought to you by the Southeast Asia IP SME Helpdesk and BeluxCham Vietnam, and also thank you for our co-organizing partners, BeluxCham Thailand, Malaysia, Spanish Chamber of Commerce in Vietnam, and the Portuguese Chamber of Commerce in Vietnam. My name is Nora. I'm the project manager of the Southeast Asia IP SME Helpdesk project, and I will be today's webinar moderator together with my colleague, Benoit, who will join you later. So just a quick overview about the housekeeping rules for this webinar. So very important point, you see a Q&A box on your screen. So if you have any questions, please type in any questions and we will be responding live at the end of the webinar. To see all speakers, please use the gallery function on your screen so you can have a good overview on the slides, but also the panelists. I would like to introduce you to our outstanding speakers of this webinar. So as you can see, we have many speakers with us today. So first, we will have Professor Harold de Walque, lecturer at the Solvay Business School in Vietnam. Will followed by Eddy de Cuyper, customs counselor based in Indonesia, in Jakarta. Then we will have Franck Fougere, external expert of the Helpdesk and managing partner of Ananda intellectual property firm based in Thailand. Then Benoit will wrap up with some case studies. He's the IP business advisor of the Southeast Asia IP SME Helpdesk. And the closing remarks will be delivered by Bart Verheyen, chairman of the BeluxCham Vietnam. And well, you can have a quick look at the agenda. I will not go into details now to save time for the exciting presentations. And then we have, yes, I am the first point on the agenda with an overview of the helpdesk services, but I believe that you all watched already the video, so you have a good overview on what we are doing, but just let me just highlight very key points. All services offered by the helpdesk are free of charge, and we support small and medium-sized enterprises, startups to protect their intellectual property rights in relation to Southeast Asia. So if you have any IP concerns, you can contact us. You can see on this screen our website details and also email address, so feel free to get in touch. And then, without any further ado, I would like to give the floor to Harold now for the welcome remarks.
Good morning and good afternoon, everyone. I'm delighted to be with you today to share a bit of insight about the IP industry. I worked in that fascinating industry for the last 15 years, having ended my journey 5 months ago, precisely. I founded the only global IP case law database called Darts IP. So it gave me quite a bit of knowledge about what's happening in that field, though I'm not a lawyer or a patent expert myself. I also live in Vietnam for the last 5 years, and I lecture on entrepreneurship topics, among others, for the Solvay Business School here in Vietnam. All that together give me this good insight on the importance of IP in general and in ASEAN in particular. More and more, I'm so happy to see that the companies I'm supporting, they see how important IP matters are for them. And the why they attach importance to the IP is because they understand that IP protection is only a part of a much larger process. Trademark protection is part of the whole branding and marketing strategy. Patent itself is a part of the innovation strategy. So in those overall process, IP plays a key role. So why do they protect their IP roles? I will outline a few important reasons that I see. The first one is to ensure for their product and services market access. We will see that very well with Eddy, who's going to talk to us about customs issue in a few minutes. They push a lot of importance on IP because of technology transfer. If you want to sign agreements with other companies, you need to be sure that you have the right IP options. And last but not least, something that we see more and more is the importance of IP for any due diligence. And with SMEs, due diligence can come very frequently. That's a very important why they do it. So, and a question I often hear also is it complicated? The filing part, in my business perspective, is not complicated. You can get outstanding advice, either locally in Belgium, if you are based in Belgium, or regionally, whether you are in Vietnam, in Indonesia, Thailand, you can get local advice. What is very important is to note that there is a variation in terms of how complex IP is in different ASEAN countries. It's not exactly the same to deal with courts in Singapore or in Indonesia and Vietnam. And here comes my own experience. As a case law database, we could never get a full comprehensive coverage of what's happening, for example, in Vietnam, in Indonesia, or a few other countries, because not all the decisions are shared. And to me, in my perspective, not having access fully to the court cases makes prediction and anticipating what parties are doing in IP much more difficult. An important aspect of IP for companies is, of course, the cost. Again, here, there is a first step that is reasonably costly. It's the filing part. So we would, in a business perspective, I would really encourage companies to file in ASEAN. And maybe the more complex or more costly part, which is defending your rights or attacking based on this filing, can be decided at a later stage. In short, IP rights are well protected in ASEAN, and you should try to acquire them as early as possible in your journey in those countries. I will finish by thanking BeluxCham to bring again such a wonderful topic for its members, and you IP Helpdesk to give such a great support for SMEs doing business in the region. Eddy, the floor is for you.
Yes, thank you, Harold. And then now, Eddy, you can share your screen to go ahead with your presentation. So please. You are muted, Eddy. Cannot hear you.
Okay, normally I should be back on the speaker for everybody. Okay, firstly, I'm going
just try to put it full screen, please.
Yes. If my computer wants to do it, yes, okay. Firstly, I want to thank certainly the IPR desk and BeluxCham to give me the opportunity to have a little word here. Because I feel also related to the IPR difficulties, but I'm doing much more, and I will present you a little bit about myself. I'm Eddy de Cuyper. I am an experienced, because I don't want to use the word old, I'm an experienced officer of customs. I worked for 37 years in Brussels airport, and then I moved to China, to the Belgian embassy in China as customs counselor. And in 2018, I came to Indonesia to do the same job for Indonesia. And happily, since June, I'm also responsible for Vietnam. In August, it was also for Singapore. And I hope in a few weeks also for Malaysia and Thailand. Firstly, what is customs, or what are customs still doing? And that's the same in each country. It's in Belgium, it's in all the Asian countries. They try to have a little bit finance, import duties, excises, VAT for their government. On the other side, they try to help in facilitating. The authorized economic operator is a very big example of that. You can do a lot of things when you are certified as authorized economic operator. And for example, in Belgium, we also have the CCC, the Customs Competence Centers, where we as customs are helping a lot. The two other things to protect and to safeguard, I took on the next slide, because then we go in the cooperation, the fight against fraud. We have the drugs. The situation in Antwerp is very bad, with 66 tons of cocaine and other drugs. We are working together with other customs for waste and pesticides. We are working on the CITES, the protected animals and plants, and also on the counterfeit. And then I come in the domain of the IPR, where we as customs, we are at the end of the line, where we can find the counterfeit goods And you can see a lot of cigarettes, DVDs, jewelries, clothing, whatever. Also the latest new trends in everything what has to see with COVID. These numbers you see here are only the Belgian numbers. So if you go to the whole world, it's of course a very big quantity. If I look to the Belgian customs attaches, we are in those countries, Brazil, Russia, India, and myself, Indonesia, Vietnam, Singapore, Malaysia, and Thailand. What are we then doing? And the first thing is a kind of networking to see and to be friends, or at least know all the people we know to do our job. I think about Belgian embassy, Belgian police, the regions, FedAwex Hub Brussels, but certainly my colleagues of the customs authorities, the food agencies, whatever, and the higher organizations like World Customs Organization, European Union, and things like that, so that we can closely work together. In this thing, like facilitation, already said a little bit about the authorized operators, security, stopping the fraud, finding everything what is not correct. Of course, to do this, there is a very big cooperation between the customs authorities of the different countries, and that's a little bit the reason I'm here in these countries, to have agreements about working together, capacity building, exchange of best practices, and so on. The third thing is then where, again, I find the IPR inside is the enforcement, again, working together between two customs authorities. For Vietnam and Singapore, we are happy that we have a free trade agreement, because in the free trade agreement, there is also always mutual administrative assistance in customs matters, so that we have a legal basis to work together on all kind of drugs, CITES, IPR, cigarettes, fiscal fraud, whatever is happening, we have the real basis to work together. And then, okay, what is it that I can do for you in case of economic support? That's also one of my big tasks. I can explain, guide, and inform you about customs procedures, taxes, economic procedures, and I do it both ways. You want to know something about importing in Belgium, or you want to know something about importing in the Southeast Asian countries, I do both sides. To customs, to the quarantine people, I can help you. I don't prefer to do that because mostly it's too late, but if you have blocked shipments, blocked containers, because you didn't know how to do, it's a little bit more difficult than giving you the information in advance. Eventually for private persons, movement or whatever, or things, I can help you. And then again, the cooperation with all kinds of services. This is a little bit my last slide in overviews, a little summary about all the things. Certainly in the free trade agreements, you have doubts, I can help you. The HS codes, the taxes, how much tax we have to pay. And again, if customs find IPR fake, counterfeit goods, of course, we work together with customs, and I'm very happy that in future I can work together with the IPR desk because they are, of course, much more experienced in this field than me. And I think I will have a very good cooperation, or I can give them a cooperation. I think we can do very well. So that was very fast. My underdeal, again, thanks to the BeluxCham and the IPR desk to give me the opportunity to do it. And Nora, you can give the floor to the next one.
Thank you very much, Eddy. It was really great to have you for this introduction, and I hope that we can mutually increase awareness about our activities, because there is a lot to do together, and I think this is the benefit of Belgian companies as well, to come to us and request support. So now I would like to invite Franck to proceed with the deep IP presentation. I already see your screen, all good. So thank you, Franck.
Thank you very much, Nora. Good morning, Europe. Good afternoon, Southeast Asia. My name is Franck Fougere. I'm the managing partner of Ananda Intellectual Property, one of Thailand's top-tier IP firm. My topic today will be to talk about how to protect your trademark and innovation in Southeast Asia. Well, in fact, the topic is how. The key question you should ask yourself is, what should I protect? So how to identify IP asset? And the next question is, why? Why do I need to protect intellectual property? So the three key questions is how, what, and why. Now, of course, I would like to say a few words about the current situation in Asia, because there's been many discussion for many years about the need to protect intellectual property, especially in this region of the world. And what I would like is to look at two things today. First, of course, look at your own company, your own intellectual property, identify these assets and understand why maybe you have an advantage in protecting them. But I wanted also to give you some of the perspective of the current situation in Southeast Asia regarding intellectual property protection. All of these in the light of the crisis that we are going through since 2019. Everybody knows that the COVID has impacted business. And interestingly, it has also impacted how intellectual property protection is effective in this part of the world in particular. So everybody knows that in times of economic recession, the filing of intellectual property rights or trademark applications, design patents tend to be less than when the economy is booming. And this is especially true for SMEs because SME will prioritize expenses, and in difficult times, they will usually think of IP as a cost more than an investment. While they may not think much about IP in good economic times, in difficult times, it may be an even harder decision to be made, especially compared to large companies who are not changing much in their IP strategy because they have planned this before, they have long-term ideas to protect their innovations, their patents, their brand. So they have already decided on the budget and they will go through economic recession without changing much, maybe, of their IP strategies. But clearly, this crisis has had different impacts on different industries. For example, in Southeast Asia, we can see that all companies with ties to the tourism industry, hospitality have suffered considerably, having to close business and for some of them, not giving priority at all to the management of their IP assets. If we look at the global statistics in terms of IP filing, we can see, however, that the impact of COVID in 2019 hasn't been as much as one could think. Yes, there has been less patent filed worldwide, about 3% in decline. However, we've seen more utility models being filed, and we've seen more trademark applications being filed, as well as industrial design. In other words, while the economy was not doing very well, the IP filings have continued to increase. And this is particularly true in Asia. And I think this graphic can show you that the majority of IP rights that are being applied for in the world today are actually made in Asia. China, of course, is included, But Southeast Asia is also increasingly a market where intellectual property is important. You can see, for example, that 98% of utility models in the world are found in Asia. We'll talk about this particular type of IP protection. And 71% of the trademarks are applied in Asia. Over 15 million trademarks were applied for in 2019. We can see also that through this crisis, some brands have really been able to grow. And if we look at the rankings of the top world 100 brands that you can find on the website of Interbrand, you can see, unsurprisingly, that in the fields of technology, media, business services, financial services, and electronic, we have new players and very strong brands. Amazon, I think everybody during COVID shopped on Amazon or other e-business platform. Obviously, digitalization companies, software companies such as Microsoft, Apple, Adobe have done very well. And then what were you doing during all this time at home during COVID? Of course, you were watching Netflix and you were listening to some music. So brands such as Spotify, Netflix, or Nintendo have come very strong. And this is all directly related to the COVID situation. So what is interesting with COVID, and this is why I wanted to start this presentation by talking about the impact of COVID, is that particularly in Asia, we've seen the COVID amplifying or accelerating some trends that we could see for many, many years as IP practitioners. You know, when we file patents, we have actually a possibility to see inventions before they actually reach the market. Now, we could see that a lot of the innovation currently in Southeast Asia relates to everything that is related to digital economy, software, electronics, health, pharmaceutical. You know, these are the key areas where we see patent applications being filed. And we can see that some of the trends have been clearly amplified by COVID. The dominance of Asia in terms of innovations in more and more technical fields, the rising importance of the Southeast Asian markets, especially for big players such as Europe, USA, and China. So this is a very interesting consumer market with a growing middle class. So very important place for these big players to protect their IP assets. We have seen, of course, a very strong acceleration of the digitalization of marketplaces. You know, I mean, all of us, we are now buying more and more goods online that are being even delivered to our door by this messenger services, something that we were not used to do just 2-3 years ago. And the crisis has also revealed that there is a need to rely more and more on IP assets to maximize growth and maybe to reduce also some kind of exposure to the economic risk. Think of yourself, if you are the owner of an IP right for software, you will still have a good business even in a difficult time because you have less employee, you're franchising, you're licensing your IP assets. Even if you are licensing a restaurant brand, you still have less risk than a restaurant owner that carries its business under its brand. So IP allows you this type of flexibility and possibility to go through a crisis as we are going through right now. But of course, in the current situation, we have seen also the worst of intellectual property with, of course, counterfeiters being very quickly able to adapt to this changing situation. While it was not possible to travel, of course, goods were still going on boats, and this has not changed. In fact, it was maybe more challenging, and I think, Eddy, you probably would agree with that. It was more challenging to do enforcement for police officers, for custom officers, not even mentioning that a lot of courts had to postpone hearings for several months or years because they couldn't have in-person hearings. So all this has created additional burden for enforcement authorities. And more importantly, the rise of e-commerce platform offers a real paradise for counterfeiters to sell all kinds of products in a very relaxed environment. You know, a lot of counterfeit goods today cross the border in small parcels, not always in big containers that the custom officers can seize, and that is very difficult. People buy directly from counterfeiters, for example, in China, and they receive these products anywhere in the world. And of course, in every crisis, there are some opportunity, and counterfeiters have seized that very well in proposing all kinds of counterfeit items, fake masks, fake gels, or even some pharmaceutical products that were presented as being cure for COVID, which of course were not. So in conclusion of this introduction, we could say that understanding the current situation is a very important first step to know what to do with your IP. Clearly understanding the market conditions and the challenges and opportunities that COVID is bringing will help also IP owners to make a better decision. What we can see on one hand is that because of the difficulties that COVID has created, you know that necessity is the mother of all invention. We will actually see more innovation, and it's already happening in many technical fields, that COVID is actually a catalyst to some innovation. We can see also the opportunities that are given now to every company to sell products online and accessing a world of consumers, so not just in local markets, but potentially everywhere in the world, which in terms of IP creates different strategies. Do I need to protect my brand only in one country, or do I need to secure it worldwide, since my products will be likely purchased by consumer all around the globe? What the crisis has shown also is that companies who rely on IP assets have usually more flexibility because they have other potential of collecting income, in particular income generated by the IP assets. And last but not least, which I see as one of the very important change, especially for Southeast Asia, is that when we look at the different intellectual property office across Southeast Asia, we can all agree that there's a lot of disparity. Clearly, if you compare Singapore with Myanmar or Laos or Cambodia, you will see different delays, different costs, different procedures to secure your IP rights. However, in all countries, the COVID has had the effect of pushing online registration system, which makes it much easier and cheaper to get IP protection in these countries. In the country I live for the past 20 years, which is Thailand, it was COVID that finally allowed the Thai Department of Intellectual Property to have an online filing system that works, because it was no longer possible to file the patents or trademarks in person. So some very, very good change brought by this situation. To conclude this introduction, I have a quick question, if you can answer it. So the question is, I'm interested to know, did the COVID-19 impacted the protection of your intellectual property? Have you been more copied? Have you had to change your strategy? Question, answer A, yes, absolutely. B, no, not at all. C, I'm not sure, which is a fair answer as well.
Thank you, Frank. So for the participants, we give you 30 seconds to decide what is the right choice for your business case, and then Frank will comment on that. Don't worry, there is no wrong answer, so just go ahead and choose something.
All right. I think
okay. Yeah, let's close the poll and see the result.
All right, so it's quite interesting. I mean, we still have about a third of the participants today said yes, which is expected. No, it's a little bit of a surprise to me, but maybe I am not sure we'll have an opportunity to change the answers when the second pool question comes, because there will be another question later on after this presentation. And maybe you will realize actually that the current situation is impacting you. So thank you for the votes. So my second party is, very classical, just to let you know about the different types of intellectual property rights and how to protect them. So sorry for those experts who already know about this, but this presentation is intended for SMEs who may not know what are intellectual property rights and how to protect them. So we have different types of IP assets: trademarks, patents, design, copyright, as well as domain names. I will focus mostly on trademarks and patents today. So the trademarks or marks, what do we call a mark? I think you all know what it is. This is the general definition of a mark. It's any sign that can be represented graphically. It can be a word, a symbol, an image. And what is important is the function of the trademark, which is to allow the consumer to differentiate one product or service from a company, from a different company. Now, there are legal requirements for trademarks to be accepted for registration, to be protected. A trademark needs to be distinctive. 2, it needs to be available. And then, of course, it should not be prohibited, for example, not contrary to public order. There are different types of trademarks. The very common type of trademarks that we see every day are the so-called semi-figurative mark, which are made of stylized characters or characters and a logo or device. We also have word marks, where the intent here is just to protect a name, regardless how it is stylized. We have figurative marks that we call also logo or device marks. It's just a graphic. And then we have another category of trademarks, which I will not elaborate too much on today because they're a little bit more complex, but which we call non-traditional marks, which are more and more accepted across offices worldwide and in Southeast Asia. I will cite 2 types of non-traditional marks: the sound marks. So for example, the ta-da of Microsoft, when you open your computer, this is considered a sound mark, and a 3-dimensional mark, which overlaps sometimes with design patent in the since they protect the shape of a product that has acquired such a distinctive character that it is now perceived by the consumer as a marker of the origin of the product. So it's not all shape of products, but these are the ones that actually function to indicate the origin of a product. To protect a trademark, it's fairly easy. Every country has the same system. You need to file a trademark application where you need to indicate the name of the applicant, the logo or the name you want to protect, and then you need to choose from an international classification a class of product or services. Remember that trademarks are protected for specific countries. There's no such thing as an international trademark that will automatically protect you worldwide, but you protect in the territories that you designate and for the specific products or services that you list in your trademark application. What are the issues, especially in Southeast Asia, when it comes to trademark? First of all, you need to ensure that your trademark is available. Of course, if someone has an identical or similar trademark filed or registered before you, you may not be able to obtain protection. We see that as a very frequent mistake of SMEs. Even some companies that start launching a brand or product or advertise it, show it at the fair, if they have not protected the name, they may run into some difficulties or unnecessary expense later on, because when they try to protect it, they actually find out that the name was already taken. There are many trademark databases that are free of charge that you can use online, including the very famous TMView and ASEAN TMView, which you can check free of charge. If you have the idea of a name, please use this database to check if this is available. And the second issue is, of course, for trademarks that are descriptive or suggestive of the characteristics of the products or services. For example, this trademark Beauty Plus, which is for an app that you use on the phone to make yourself look pretty. This is considered, although it's for software, this will be considered a descriptive trademark in some countries because it tells you what the function of the app is about. It's to make you more beautiful. Another issue that we see with trademark application being filed in Southeast Asia is that you need to be very precise in the description of the products or services that you want to protect. If you are too broad, for example, clothing or cosmetics or pharmaceutical, probably the trademark office will ask you to further describe what type of products or services you would like to protect. How to choose the right name? This is a general recommendation, but you know, the more descriptive, the more generic your trademark is, the less likely you will obtain protection. The best brands are the ones that are original, such as Conword, think of Xerox, Kodak, or Coca-Cola. Trademark applications are protected for 10 years. You can renew them. Understand that in Southeast Asia, there is no regional system of protection. You may have heard about the European trademark in Europe that allows you to protect your trademark in all countries of the European Union, except UK. They are out, as everybody knows. Now, there is no such system in Southeast Asia, unfortunately, because you know, the ASEAN is becoming more and more integrated with the AEC. However, there's no currently regional system of protection, neither for trademark nor for other types of IP. But we do have the international trademark system, also called the Madrid system, which allows some form of harmonization among all the countries of Southeast Asia. With the exception of Myanmar, all other 9 countries of the ASEAN are member now of the Madrid system. How the international trademark system works, very briefly, you first need to apply for a trademark application in your country of origin or the country you are national from. So for example, if you are a Vietnamese company, you will need to apply first for a basic trademark application with the Vietnam Intellectual Property Office. And then on the basis of this basic application, you can file an international trademark application, which is managed by the World Intellectual Property Organization in Geneva. So it's a form where you designate, you indicate all countries where you would like to seek protection. So if you would like protection in Thailand, Singapore, Indonesia, Malaysia, you have 2 options. Either you file national application in each of these countries. That means you need to select a trademark agent in each country, or you file a basic application in Vietnam, which is your country of origin, then an international application, and you designate the countries of interest. The advantage of that is that it may be well cheaper and faster to obtain protection. Talking now about innovation and patents, there are 3 types of patents generally recognized and that can be protected in Southeast Asia: patent for inventions, petty patents, and design patents. Each of these has a different terms of protection. Design patents are minimum of protection of 10 years up to 15 years, and patent for invention is 20 years. What are the difference? Design patent, as I'm sure you all understand what a design is. There's different types of design that can be protected. First, shapes, the shape of a product, but also patterns, combination of lines or colors. We're talking here about 2-dimensional design. And last but not least, as it is increasingly important, graphic user interface, which are also registrable under certain conditions in some countries under design patents. Whereas trademarks do not need to be new to be protected, know that for patents and for design, it is an absolute necessity for the designs to be new. So if you want to get protection for the shape of a product, for example, don't show your product or don't sell it before you have applied for design patent protection. As I mentioned, you can file national application in front of each IP office. There is no regional system of protection. There is an international design protection system called the Hague system. However, it is not yet very popular in Southeast Asia. It's only available in some countries, Brunei, Cambodia, Singapore, and Vietnam. The other ASEAN countries have not yet joined this system, but it's part of the objective, the ASEAN objectives for these countries to join the Hague system. Thailand, for example, is considering joining as soon as they adopt the new Patent Act, hopefully within next year. The Hague system works a little bit differently than the Madrid system for trademarks. It's a little bit easier to understand. You can file an international design patent application and designate the countries where you would like to get protection. Currently, I believe there's only 75 countries in the world member of that system, but that number is increasing rapidly. And there are several advantages of using this international system. So for example, if you're listening to this presentation today from Vietnam, Vietnam being a country member of that system, know that you can use it to your advantage. You can protect in one application up to 100 design, and the protection will be also considerably longer than what you could get maybe through other forms of protection. Through the international system, you can get up to 15 years protection for your design. Regarding invention patents and petit patents, so I will just make a quick distinction between the two. The patents for inventions, they cover the function, the operation, or construction of an invention. They are quite difficult to obtain because not only your invention needs to be new, but it also needs to have an inventive step, meaning your invention should not be obvious for someone skilled in the art. Therefore, it's quite difficult, especially for inventions that are fairly obvious. And in Asia, it's very popular to opt for a shorter term of protection, which is called a petit patent or utility model, which gives a shorter time of protection, but it's also much easier to obtain because you just need to satisfy the criteria of novelty, but you do not need such a strong inventive step. So it's very popular. You remember in my introduction, I mentioned that 98% of the utility models or petit patents are filed in Asia, and this is actually a category that's growing. It's very often neglected by foreign applicants, in particular by European companies, because they only think about the 20 years protection for patents. Whereas actually, if your technology is something that you do not require 20 years protection, a petit patent might be a faster and cheaper way to get protection. It's only 10 years, but it's cheaper, and it could be sufficient, especially if it's an invention that is not groundbreaking. Third type of IP rights that you should also consider is, of course, copyright. And I mention this because it is also very, very often neglected. Copyright is actually everything that is tangible, any ideas that you put on paper, any music that you record, any literary content, and of course, and this is very important, computer software. And in many products today, you have software, technology, so do not protect just maybe the technical function of the product, but think also of protecting the software. Sometimes you are infringed on the software, or your product is infringed with the software in it, and copyright protection can be a very, very powerful tool if you know how to use it. With copyright, the protection lasts for 50 to 70 years after the death of the author, and there is no compulsory recordation or registration of copyright. If you can prove that you are the owner of the copyright, that is sufficient. Now, the challenge that we see, for example, let's take the example of software, is that copyright is usually vested in the individual, in the author. So for example, the developer of the software, the programmer, and not necessarily the employer. or not necessarily the company that contracted freelancers to develop the software. So make sure that the copyright is owned by you by having assignment agreements. If you pay for someone to design a product packaging, your contents of your website or software, make sure you have an agreement that what you have paid for, the copyright belongs to you. In conclusion, I would like to give some recommendations that I hope everyone will find useful. I think the first thing, the most important thing is really to know yourself, to know what do I have to protect and how to prioritize and strategize this. A lot of people, when they think about IP, they think about the trademark first. However, if it's a new product, the trademark is not known yet to the consumer. The main asset may not be the name, may not be the trademark. Check that it is available before you start using a name. That is the recommendation number one, because otherwise you might run into difficulties or you might be infringing someone else's right. But really look at what you are selling and whether the trademark is the key asset for you to protect. It might be copyright. If it's a software that you have developed, it's more important that you ensure it belongs to you. Or it might be a design if it's a new product with an original shape, and therefore you might want to use your budget to protect the product rather than the name of the product, or to protect the technology rather than the name of the technology. So prioritize your IP asset. What is the most valuable asset and how much money do you want to spend? And then you need to understand why you would like to protect it. Is it just because you're going to get copied and you want to have an exclusivity? Is it to prevent competitors from entering the market or imitating your product? Or is it because behind this, you have a strategy that you will license, that you will commercialize your IP? All of these are questions that you need to ask yourself before deciding on your IP strategy, because there is no one single IP strategy that fits for all. So understand what the priorities are, what you want to do with it, how much money you want to spend, and then work out the best strategy for you. The second question is, after you know yourself, which is already a big question, understand your environment, because companies are not operating in a void. They have competitors and they need to understand the market and the change that occur in their environment, in their business environment. Clearly, COVID, as I said, has a very strong impact. For example, in the commerce, in the trade of goods, e-commerce. While before your products may only be sold locally, suddenly you're trading on Amazon or Alibaba. Do you need to protect your brand in the US, because maybe some customer will purchase your products in the US? Are you infringing someone else's brand in Europe or in the US if you sell from Vietnam? So all these are questions that you need to ask yourself. Once your product is online, essentially your IP protection, which is territorial, may come into conflict with other IP rights in other countries, and you may also need to revise your protection needs to address the fact that you are now talking to a global market. Make sure also that you keep an eye on your competitor. That's really an important advice I see often. SMEs, in particular in field of innovations, they always come saying, oh, I have the best idea. It has never been done before, and for sure I will get a patent for that. Well, know how to use the database, in particular the patent database, to check what's out there. The database of the European Patent Office, ESPASnet, is great. It's free of charge. You can search by keywords. You can see who has patented something in the field that I would like to get a patent for. And that can save you a lot of money in research and development, or even patent fees, if you realize actually that this has been done by someone else. Last recommendation, be knowledgeable, be resilient, and be creative. Be knowledgeable, this is what I just say, know the law, know how to use the information that you can get online, monitor any case of infringement. Be resilient. This is especially true in the current times we're going through. Keep your brand protection. Keep enforcing your IP rights. Counterfeiters are very quick to see which trademark owners may not be very active in protecting the IP assets. If you spend a lot of money protecting your brand and then you never take action to bring counterfeiters to justice, you will always have issues with counterfeiting. But be also flexible. You know, sometimes your products can or your company can adapt to changing situation. In France, we've seen perfume companies such as Dior starting to produce hydroalcoholic gel to fight COVID. And we've seen companies that were, or restaurants, you know, that were only doing service in dining, suddenly developing home delivery services. So all of this flexibility is what helps to go through crisis. And of course, as the business adapts and evolves, make sure that your IP protection follows these changes. If suddenly your business is no longer to operate the restaurant, but to operate hundreds of motorcycles to deliver goods, not just food, but all types of products through the city, maybe your business has changed from being a restaurant to being lineman, and then therefore you should protect your brand for this new activity, which, by the way, might be more profitable in the long run than your restaurant. Last but not least, of course, I say that to every company that does IP, keep being creative. Creativity is the beauty of intellectual property. This is the source of wealth for the society and for company. So make sure to stay creative, to come up with new design, even if you have less money to spend in R&D and come up with new inventions. There's endless design possibility to make your product attractive to the consumer. Think of IP as a tool also to reach business objective. Look at the case study. There are many on the IP SME Helpdesk, you know, a successful story. Just to name a few, co-branding, two companies coming together, putting their brains together to manufacture or to distribute a product, touching different consumers. We saw a lot of examples of that, a very successful one. Instead of trying to exploit all your products by yourself, maybe consider licensing it in other parts of the world where currently you have no markets. And then think of all the advantage that intellectual property rights can bring to you. Thank you very much.
Thank you, Franck. It was a really insightful presentation. I think it was very nice to link it to the COVID context as well, to advise companies to adjust to new trends. So now to wrap up the IP part, I would like to invite my colleague Benoit Tardy to introduce a case study of an EU SMEs and give some takeaway messages to the participants. And after, we will have the live Q&A. So please, those who already asked questions, please hold on, and we will answer live your questions in a few minutes.
Thank you, Nora. And yes, and while I'm speaking, for all of you, do not feel shy, and please keep on sending questions for us. So we are very lucky because we were provided with some data from a colleague. So we have a nice case study, let's say, on in Thailand about patent infringement. So as you can see, it was a Belgian company, Inve Technologies NV, versus several Thai companies. I will go very quickly through the facts. So in fact, there were 3 defendants, and they jointly infringed.
Sorry, Benoit, we don't see your screen.
Sorry, I thought you were sharing.
No, we can share, but
yes, please, because I do not have the.
Okay.
Can you move the slides? Okay. So I'm okay. I have the control now. Okay, perfect. So there were 3 defendants, and they infringed a patent, invention patent on protecting the process to produce Artemia nopli, which is like a very small crustaceans. It's also called sea monkeys, and the infringement was covering the production, the use, the sale, and the possession for sale, offering for sale, importation, many other activities. And all this was done without the permission from the plaintiff. So in fact, the defendant claimed that the process and the ingredients were different from the plaintiff's invention. This is like the normal defense, and that there was no infringement of the patent. The plaintiff, which is Inve Technologies, the Belgian company, examined all the defendants' products, and they found out that indeed they were using the compound containing hydrogen peroxide and was used for the process to increase the rate of egg hatching. So in fact, this was identical to the claim protected under the plaintiff's patent. Very surprisingly, the defendant, but it's also very commonly used technique, hired an agent, specific like internal private agent, to examine all the defendant's products, and they found out there was no specific compound, and the process was different. Okay, so there was some tests done, and the plaintiff requested the defendant to send samples, and eventually it was obvious that there was an infringement. So I was just sharing some figures with you, but I will go quickly. So the plaintiff calculated the whole amount of damages, and it was quite a big amount of money. And the defendants kept on producing, selling, importing the invention, even if there were already some negotiation discussions between parties with deceased letters and also patent attorneys involved. But nothing was happening, nothing. So I would just go through the ruling very quickly. It was first instance, and there was no appeal before the Court of Appeal. So the ruling was issued in November 2018. And as you can see on the slide, they had to stop the infringement because they were infringing patents from the Inve company, the Belgian company. There was also a huge amount of money to be paid as damages, also bearing damages for one of the defendants, and all other claims were pushed away. Why I wanted to share about this specific case study, in fact, it's just to remind SMEs, European SMEs, Belgian SMEs, the most important things. In this case, it's register your right. Here, register your patent in the countries or territories where you have an activity. It could be either a direct activity or an activity through a local partner. So the story would have been here very different if there were no registered rights for Thailand. The second part is monitor the market, monitor your competitor in order to be as much reactive as possible. It's always a matter of time. The sooner you react, the better. IP, as it was already said before, IP is territorial, so you have to be aware of specific IP rules, local IP rules, and practical rules. And basically, we always recommend SMEs to also contact either the IP office, the local IP office, or some IP experts. Like you could also contact Franck for Thailand, but also for other countries. IP courts in Southeast Asia are quite effective, and they do issue sound decision. So here we had the case, the perfect case, as there was an infringement stop issued, and also some damages to be paid to Inve. However, what we usually see and notice is that the level of expertise and specialization of IP courts, IP systems is very different from one country to another within Southeast Asia. And for example, there would be no specific IP court specialized yet in Vietnam, but this will soon change. And in Myanmar, it's still like in development. And last but not least, with this case, it's very positive to see that sanctions are in fact really issued against infringers, and this cannot remain unpunished. Here, I will go very quickly through some IP data. Basically, it matches with what was saying Franck in his presentation. Even in the region in Southeast Asia, we saw a rising in IP filings and also IP issues before court, administrative hearings, also objections. We have also the same for, copyrights. Also, we selected the 3 countries. And last but not least, I will share some takeaway messages. So it's basically going in the same way as recommendation provided by Franck. So very quickly, build an efficient IP protection strategy, planning ahead. This is a key thing. Assess the assets of the company, see what is protectable or not by IP, define which IP rights may be suitable, applicable, assess the territorial coverage, register your intellectual property rights, and create, maintain, develop the portfolio of rights. This was already said by Franck. The second very important takeaway message is the territorial of IPR, of IP rights. In fact, as I was saying, you have to cover countries where you trade and manufacture, but also where you may have some potential partners. This is all part of the planning. And then adapt your strategy local and regional specificities. The last takeaway messages, it's basically why we're here today. It's increase your knowledge about IP. So you can contact, for example, BOIP, Benelux Office for Intellectual Property, UIPO, WIPO. You can also contact our help desk. And last but not least, you can also try to contact local IP offices. And basically for me, this is all. I don't know if we have the time to go quickly through this poll question, Nora, or should we jump to Q&A?
No, I think we can do the poll
Okay.
just to see
So
what participants think and then go.
So the question is, how likely will you adapt your intellectual property protection strategies in a post-COVID-19 world? Very likely, will not change. I am not sure.
So it's a follow-up on the first question, so we can see how people change their mind throughout the presentation.
Maybe Franck wants to comment on this specific poll. Please go ahead with the results.
Yeah, we can share the result.
Thank you, Benoit. Yes, I think it's a follow-up question. It's to see if after hearing the presentations, people maybe realize, yes, and you see, I think now the percentage has increased, which actually means maybe that some of the things we said also, I hope, make some people realize actually that maybe a little bit more attention need to be spent on the IP asset. You know, clearly speaking, and I'm talking here as someone who's been 20 years in Asia and starting an SME, a law firm, but still an SME in Asia, I can tell you that there's a lot of opportunities with a sound IP protection. Building a strong brand in Southeast Asia is absolutely possible. And beware of the people who tell you, yes, but everything is copied, there's nothing we can do. I think that was probably true some 15 years or 20 years ago, where indeed, you know, you walk to every city in Southeast Asia and you see all the fake products. And I do realize that it has moved to an online environment, but there's been so many efforts made in the past years to better protect intellectual property, that I think it would be a huge mistake to think that there is no law and that there is no effective way of protecting intellectual property in Asia. In fact, if most filings of IP are made in Asia and in Southeast Asia, especially by domestic applicants, you know that these people are not just wasting money and throwing money by the window. There is a reason why they're securing their trademarks, their design, their patents. It's because they have an economic advantage to do that. And the faster European companies, in particular SMEs, understand that, the more likely they will be successful in their strategies in Southeast Asia. Because I can tell you, the Chinese and the local Asian companies have now very well understood the potential of intellectual property. So we cannot, as European, we cannot just think we know better or we don't need to do it because we don't believe in it. IP was born in Europe. It's the Paris Convention, you know, and if we are serious about protecting IP, then we should do it, especially in this part of the world.
Thank you, Franck, for these nice remarks to close the presentation session. And now I would like to give the floor to Benoit to moderate the Q&A, and also encourage the participants that you can still send questions through the Q&A box and also in the chat. I saw that Franck replied some questions during the presentation, so thanks for that initiative. Very, very pro. And then I also saw a question in the chat box. I don't know if you noticed that, Benoit. I let you handle from here.
Yes. Let me check. It was a question from Bart. He was asking, are there any off-court? Actually, I cannot see anymore the question. That's why I tried to remember. Sorry.
If you want, I can remember the question. I can repeat the question if you want. My question was: does every Southeast Asian country has a let's say arbitration procedure to settle disputes about EPR content, to settle those disputes outside courts? Is there arbitration in those countries in Southeast Asia?
So maybe I can answer that one. The answer is yes, generally speaking, and it's growing in importance. And there are very simple reasons for that. One reason is when you have an IP dispute, you sometimes do not want the whole world to know about it. If you have a patent dispute, for example, and it's two competitors, you may want to settle this quietly outside of the courtroom, also not taking the risk that you may have in facing a judge, you know, that may not be very well specialized or qualified enough to make a proper decision. So in the past years, arbitration offices have been set up in many countries in Southeast Asia. I can talk the example of Thailand, which I know very well. There is a new Thai arbitration center who has recently signed an MOU with the Department of Intellectual Property to actually promote this alternative dispute resolution mechanism. One thing that we need to make a distinction is, on one hand, the arbitration, which usually when you submit to arbitrators, that is because both parties have agreed, or there is an agreement that says that to solve conflict, for example, between a licensee and a licensor, they will arbitrate. So they have chosen already to not go to court, but to elect arbitration. A lot of these agreements are actually made with arbitration provision, for example, using Singapore law or Singapore as a place for arbitration. Very, very common in Southeast Asia to choose in IP agreements the Singapore law. But the other aspect is the mediation. And here, many IP offices also offer mediation. So in other words, again, the two parties must agree, for example, the trademark owner and the counterfeiter, and they will bring the small dispute in front of a mediator, which is an administrative officer of the intellectual property office that will listen to both parties. This is all confidential, and will suggest a solution that both parties can agree. If no agreement can be found, they will still have to go to court. And that is particularly useful for small cases, you know, the small case that you do not want to go to court. For example, street vendors, people who have sold a few products on social media, on messenger apps, this kind of thing. You know, you don't want to go to court because you don't have very strong evidence, or the IP owner doesn't have the money to, you know, pay for court fees and all the procedure, which, by the way, may take years, despite Southeast Asian countries having more and more specialized IP jurisdiction. So definitely exploring alternative dispute resolution mechanism is a very good recommendation, and thank you, Bart, for mentioning this as an alternative way to the courts.
And I would just add a small comment. We also recently did a webinar also on alternative dispute resolution, and we can tell that there was a very high interest in Vietnam and some other countries. So yes, it's definitely a topic to follow. I have a quick question for Eddy. Someone asking, how does it work with you when you are contacted? Are you able to, well, I guess right now it's difficult to be on site, but how would you be able to assist Belgium, a Belgium SME, for example?
Okay, I'm unmuted. No, indeed, yeah, we work from home a lot of times, but that doesn't mean that everybody works from home, or officers are still working in airport, ports, and so on. So I see, in fact, our role as customs a little bit coming after everything what was explained here. So you do the registration of your trademarks, you do whatever you want. And then at a certain moment, customs can stop a shipment with your goods, or maybe counterfeited goods of you. And then we need mostly to contact the company, and the company had to start to put a complaint, and then we can seize the goods and can everything go to court. But I know that all these ways of customs is a little bit different in each country. What I am explaining is a little bit the European, the Belgian way, but I'm still studying the practice of customs in the Southeast Asian countries. And it is my aim to make maybe in a few months a presentation about the different ways that customs are dealing with fake goods, with counterfeit. So you have possibilities that if you register in customs in advance, customs will act for you. Other possibilities is that customs are maybe warning you and that you have to act at that moment. So there are different things, but I view our role, customs role, is coming after what we saw today, the registration. So we can act if your product is registered, we can act to stop and to seize it.
Okay, very clear. Thank you, Eddy. And if there are any specific questions, you are also reachable, I guess.
Yes, of course.
Of course.
With all things, my details were in the presentation. And sure. If it is not my total competence, I will be very happy to find you and the colleagues of the IPR desk to help to find a good answer.
Thank you very much. We have one last question before handing it over to Bart for the final conclusion. It's for Franck. We have someone telling, if I don't have a trademark registration in Thailand or some ASEAN countries, and I found that someone is selling the fake products on Shopee, Lazada, other e-commerce platforms, what can I take any action to remove such fake products from the platforms, e-commerce platforms?
So the answer is no. The answer is no, because these online platforms will not act. They will not take down content unless you provide them with a copy of a certificate of registration of a trademark. So even having a pending trademark application will not satisfy the IP portal of Lazada, which is Alibaba, Shopee, or the like. However, there are some provisions, for example, in Thailand, that protects unregistered trademark with very, very small penalties. So you could still choose to identify the person selling the counterfeit goods and file a complaint against such person using the provision of the Thai law protecting unregistered trademark. However, the cost advantage, I think, is something that you need to evaluate carefully, unless you can really single the individual that sells the product, and you have a chance maybe to seize a considerable amount of products. It will probably be a case that may cost you more to enforce your rights than actually what you may get. In a situation like this, the best recommendation I would make is to quickly apply for trademark protection, requesting a very quick examination. There are ways to speed up registration of trademark based on this kind of evidence that your trademark is being copied and that you need a very quick protection. And within a few months, maybe you will get protection for your trademark, and then you can take action online. Remember also to add to what Eddy was saying, that a lot of the protection can be done actually free if you have a sound custom protection strategy. In most countries, in addition to registering your trademark with the trademark office, you can also record it with the custom officer, because custom officers check daily thousands of containers. And when they find products that they suspect to be infringing, they need to check the coordinates of the local representative that they may call to inspect the products to check if these are counterfeit. We call this ex officio. But if you do not register your brand with the custom, or you do not inform the customs about, potentially infringing goods crossing the border, then you may always be fighting, small sellers, whether online or offline, but you're never really able to prevent the goods from crossing borders, or you may never be able to retrieve information that will help you to go all the way to the country of export, to the origin, and eventually to the manufacturer, which is what you want to have. So a lot of the IP enforcement strategy today, and I understand this question, it's annoying, to see the counterfeit goods being offered online, but the main idea is to try to get information and try to analyze the whole chain. How is this small seller getting the products? Where is he getting from? How is he importing that? Where is this, which country? And then try to go as much as possible close to the source so that you can take more effective action.
Okay, thank you very much, Franck, for this very detailed answer. Just before switching to Bart, Harold, do you have any comments of what we discussed? Do you want to share something, or we just go directly to the wrap up of Bart?
Let's go to Bart. I think it's going to be a very happy ending for this very interesting discussion.
Okay.
Well, thank you for the happy ending wishes, Harold. What can I say? Well, this was a truly Southeast Asian webinar. Great things I learned, even for my own company. Unfortunately, I wasn't able to vote as a panelist, but for sure I would have been one of the people who answered A or number one at the last poll. Thank you very much to the whole Southeast Asia IPR Helpdesk team for making it happening today. A very, very big thank you to Nora, to Harold, to our speakers, Eddy, Franck, Benoit. Also a very big thank you to Foam from BeluxCham. I know that you have done a lot of work behind the screens to make this happen today. I'm very happy that we could organize it together with the support of other chambers. Thank you very much to the BVA, to the Belgian Vietnamese Alliance here in Belgium. Thank you to BeluxCham, thank you BeluxCham Malaysia, the Spanish chamber, the Portuguese chamber there in Vietnam. Thank you very much. Unless anyone else, Nora, wants to say the last word, I still can mention, I think, that this webinar was recorded, so we will send you the link, including the presentations. For the rest, thank you very much for attending. Stay safe and check us out for the latest new upcoming webinars very soon. Thank you very much. Bye-bye.
Thank you, Bart. Thank you for everyone.
Thank you.
We will share the recording, and really, I agree with Bart. It was a real teamwork and great collaboration. Looking forward to see you all again, and big thank you to today's speakers. Have a good day. Bye.
Thank you.
Bye-bye. Thank you very much.